Well, there are important flashes that are coming up for you on the screen. You're getting some information in terms of the Supreme Court judgment on the interest waiver case. Now, the statements that are coming, that no direction can be given to the government, the RBI, to announce any kind of additional reliefs. The RBI, so on the back of that, basically the short point is the numbers will flash for you on the screen, and the Nifty Bank, that's the one that's taken it as a relief, and that's why that's moved to the high point of the day. It's up close to 500
is sending
points.
us some more lines, yes. And this line is the most important one, where he says the Supreme Court judgment is waiver of interest not possible. Banks have to pay depositors. That exactly was the case for the banks, that we have to pay depositors. And now the Supreme Court saying that waiver of interest is not possible. And that, that is the sum and substance of it all. The fact that it's a good verdict, because the waiver of interest is not possible. Banks do have to pay. And that's something that we're seeing in individual stocks as well. Each of these banks spiking right now, ICICI Bank, HDFC Bank, not just them, but the others as well, and that's reflective in the kind of moves that we're seeing in the Nifty Bank and the Nifty too.
Well, that's right. It's moved to the high point of the day as we speak. Lata as well will join in just a bit to fill us in with more details, and maybe in fact we can just get Ashmit as well for a quick we get Ashmit in just a bit, but I think for the time being we have Mr. R.K. Bansal who's joining in, Managing Director at Edelweiss ARC, who joins in. Hi, Mr. Bansal. Well, we are getting a few statements that's coming in, from the Supreme Court verdict, and a couple of lines, I'll just surprise you on, is the waiver of interest is not possible. Banks have to pay depositors. And if in case, there is, the other statement is no direction can be given to the government, the Reserve Bank of India, to announce any kind of additional reliefs. Want your first take on it?
Yeah, I think that's the point we have been discussing throughout this period, and that was expected, because if banks have to pay depositors interest, then naturally they have to charge interest from the borrowers also. Government has already given a relief for 6 months interest on interest portion. I think that was paid by government, but interest itself cannot be waived. I mean, then banks will have problem. Then anyway government has to provide money to banks if that happens.
Right, Mr. Bansal. All right, hang in there. We're getting some more lines as well and some more details. We have Lata joining us as well. Lata, looks like a good verdict for the banks.
I think it is the end of this rather unnecessary controversy, which the legal system got us into. This was entirely a regulator and a government issue, how to help borrowers during a time of crisis. This should not have had a judicial entry at all. But the case was taken to the courts and it has taken its course in the courts. I think this is curtains, and curtains in a very positive way. The Supreme Court clearly saying that waiver of interest is not possible, and that there can be no further direction given to the courts and to the regulator. I think this brings the curtains in the way it ought to be done. This is not meant to be a judicial decision. It is a fiscal decision. The government decides how to distribute its resources, whom to help and how to help with whose money. And it is the regulator's decision to decide what is good for the health of the financial sector, keeping in mind the long-term savings proclivity of the population, the protection of the depositor, the protection of the banking system. It was entirely a regulator's terrain, and if at all a fiscal terrain. It was not intended to be a judicial terrain, and I think the judiciary has acted correctly. That would be my reading of the case. I'm extremely happy with the decision. It ends the uncertainty. There were severe fears across, serious fears across the financial sector, the banking sector, even in regulators and government circles, that what if some of the post-moratorium restructuring was pulled back by the courts. I mean, imagine the disruption to the financial sector with these kinds of decisions. Imagine the precedent set if interest was waived. So all this has been resolved amicably, and uncalled for controversy has been put to an end, and put to an end in a very positive fashion, I would think, with what I have understood of the problem. But Mr. Bansal, I think it is curtains on the case. Okay, we will get Mr. Bansal in a minute. Sunil Srivastava, the former Deputy Managing Director at SBI, joins us. Sunil, the court has directed that neither the regulator nor the government shall be given any further directions, and that the interests of the depositors also need to be protected, and therefore interest on moratorium loans shall not be waived. Your first thoughts?
I think it's a very welcome judgment because it respects the responsibility of the regulator for the sector, vis-a-vis the RBI and the government, and should be an indication of, things vis-a-vis the other regulators as well. And I would say that, anyway up to 2 crores, this has been covered, exposures up to 2 crores, which comprises of almost 97-98% of the total exposure of the banking sector. Now, there may be certain sectors which would require special forbearances, for which the representation should be made to the RBI through the banks. I would say this should not be in the, the court has rightly upheld that this should not be the domain of where they have the expertise. It should be with the regulators. So that's a very good move.
Can't allow extension of moratorium is what the court has ruled, and can't direct for sector-wise relief to the RBI. Those are the other lines that we are getting. Sunil, yeah.
Yeah, 2 more lines which have come in, and the first one, of course, is that the court can't be expected to have expertise in issues of financial and economic health. So you're talking about precedent. This is one, and the second one is granting relief such as interest waiver, extension of moratorium will have far-reaching consequences for the economy. And there's some lines coming in on interest of interest as well, where they've said that they've taken policy decision to waive interest on interest.
Okay, well, that has already been done.
Exactly.
And as you point out, hopefully this judgment, as you say, that it's not the court's expertise, will be followed in coming years as well. And the court always maintained that. In most of the previous judgments, the court did not enter into the terrain of the Reserve Bank because it was seen as a sector specialist and not something which, common people who discuss common law will interfere with. Sunil, I just wanted to ask you whether now banks will be allowed to expressly declare all those moratorium loans as NPAs. That classification standstill also had been observed. Now we will, that classification standstill will go and we will get the real NPA number, right?
So the banks, as far as accounting practices are concerned, have actually already provided for that.
Yes.
They have not recognized they just not recognized it as an NPA. But they have provided for it in their accounting classification. So I guess it's not going to be making much of a difference there. This has been provided for.
Yes.
Obviously,
And they were declaring pro forma NPA and non-pro forma NPA. So I agree with you. Mr. Bansal, now if you can hear us, it looks like it's curtains on the case, and interest on moratorium loans will not be waived. Interest on interest has already been taken care of. And the court says that this is too specialized a case for it to interfere in terms of sector-wise munificence. Your thoughts?
No, I agree. Actually, this is one area where Supreme Court especially has not interfered in RBI's decisions. I think except once when the restructuring circular, there was some issue on IBC cases being referred. Other than that, I have not seen. 6 months interest on interest has already been paid by government in most of the cases. And in fact, there was a concern in the overall system that if banks don't classify the accounts as NPA, and then that may not reflect the true picture. So though analysts and people have been taking the pro forma thing, and of course personally it impacts our business because without NPA we can't buy the assets. So, in fact, it is good judgment, and I appreciate that Supreme Court has stood by the financial system and who is the regulator.
We will replay that bite of yours, Mr. Bansal. Actually, let's go back to our correspondent Ashmit Kumar, who has been following the case and who heard out the court today. Ashmit, can you just outline the key observations?
Well, a broad view that the Supreme Court appears to have taken is that the Supreme Court is an adjudicator of law. It can't be expected to have expertise in matters of finance, of economy, and towards that end, it has pointed out that the government already has, in fact, announced a slew of various reliefs. In fact, it also pointed out that the government has taken a hit, even on the fiscal front on itself, on various occasions. The government also has its hands tied with respect to a relief that can be announced, and towards that end, what it essentially says is that the reliefs that have essentially been sought for, which are essentially threefold. Number one is a complete waiver of interest. And second relief that was sought was an extension of the moratorium. The third was sector-specific reliefs. On all of these three counts, the Supreme Court has held that it is not in a position to direct the government or the RBI to come out with reliefs, to come out with specific targeted measures that have been sought for as a part of the various applications. Mind you, it was hearing a batch of 20 applications, 20-odd applications. The Supreme Court saying that these measures that have been sought, as had been warned by the RBI in the case of the interest waiver, that it will have sweeping consequences, that appears to have been reproduced in the judgment. The Supreme Court observing that these measures that have been asked for will have large and decisive consequences for the economy at large, and towards that end, the Supreme Court, in its wisdom, has not seen it fit to grant any additional reliefs. Having said that, there is, however, one aspect to consider. The Supreme Court, again, reiterating its earlier position that as far as interest on interest is concerned, that has been determined to be a penal interest, and towards that end, the Supreme Court has said that there seems to be no rationale that has been given by the government to limit that relief to loan to borrowers who've taken loans of only up to 2 crores. So towards that end, that is one additional relief that has been granted, that interest on interest cannot be charged in any shape or form to any of the borrowers in question. So the scope has been widened. The government had limited that relief to borrowers of only up to 2 crores. That scope has been widened by the Supreme Court. So that is one decisive measure that has been given. But outside of that interest on interest waiver, the Supreme Court making it clear that the government, as of this stage, cannot be asked to take upon more fiscal measures upon its own book.
That is big. Ashmit, that is big. We have not yet covered that. If interest on interest waiver is going to be extended to all loans and not just loans under 2 crore, then there is further liability for either the government or the banks, depending on who takes up that liability. I'm not sure what that number would be. Mr. Sunil Mehta, the CEO of the Indian Banks Association, is with us. Mr. Mehta, I thought this was unalloyed pleasure for the banking system. It is a limited pleasure. The moratorium is not extended, interest waiver has not been granted, and sector-specific reliefs have not been granted. But interest on interest for all loans will have to be paid back. What do you think is the burden for the banking sector?
Lata, you are pretty well aware that banking system has already made it clear to the Supreme Court as well as to the government that the payment of the interest as well as the compounding of interest on loans is a intermediary function of a banking system.
Yes.
So we have been providing the interest on the deposits to the depositors, and the same way we charge from the borrowers also.
Okay.
Government at its own has been providing relief to the various sectors of the economy.
No, they have. Mr. Mehta, 1 minute. Mr. Mehta, 1 minute. When the Supreme Court directed that interest on interest be paid back for loans under 2 crore, the government picked up that burden. Now the court is saying interest on all loans, not just loans under 2 crore, cannot be charged. Now the banks have already charged that interest. What is that amount, would you know?
No, basically to let you know that amount is not possible today. We will have to go and calculate that amount. But ultimately, this call will have to be taken by the government because bankers are a financial intermediary, and the same stand we have taken for loan even below 2 crore, that it is the call to be taken by the government.
Absolutely.
So we'll maintain the same stand.
Yeah, then in that case, I want to go back to Ashmit. Mr. Mehta, 1 minute. Let me go back to Ashmit. Ashmit, what has the side of the government and RBI reacted? Are they going to review or appeal this to a larger bench, or in some fashion even question that they are being asked to pay interest on all loans? As Mr. Mehta is saying, this is normal banking practice, compounding of interest that has not been paid. Therefore, have we not heard the last of this case?
Well, there are 3 aspects to consider. As far as the first aspect is concerned, both the RBI as well as the centre on various occasions have said that as far as the levy of interest on interest is concerned, to allow protection and to allow relief to people, they had limited the relief to 2 crores, and they have subsequently, in fact, made various submissions before the court to limit it, to confine the relief to people, to borrowers below 2 crores. However, the court seems to have taken a drastically different view. The court has decided that this is a penal interest, that no rationale has been given by the government to restrict it, and towards that end has given its judgment. Now, as far as the judgment itself is concerned, very limited remedy available to the government in terms of possibly seeking a relief, but one gets a sense that this is a judgment that has been passed by a 3-judge bench, of the Supreme Court, and is likely, and it is bound on the government to come through on this, to follow this. So very limited legal remedies available.
What is that limited? What is that limited legal remedy? A review?
The limited remedy available to the government would be to approach the court in the form of a review application, and then subsequently before a curative application. But these are reliefs that we see only in exceptional cases where there are where the exigencies are such which require the government to act in a fashion to exercise these limited reliefs. So one will have to only speculate. One can only speculate whether the government will choose to exercise this limited relief. But that is one remedy available. Should they choose to exercise it or not, we'll find out in the days to come. For now, given that it's a 3-judge bench order passed by the Supreme Court of the country, the government has its hands tied. We'll have to comply. We'll have to fall in line with this rationale of the Supreme Court that this is a penal interest, needs to be with across the board for all borrowers, not just those limited below 2 crores.
Okay. Well, Ashmit, I'll leave you to, touch base with the government lawyers as well as the RBI's lawyers to check out, and even SBI, I think they are also there, the banks, to check out whether they will request a review on this exact ground, whether interest on interest should be charged as penal, compounding of interest being normal banking practice. Thank you very much, Ashmit, and I'm sure you're going to get us some reaction from the government side as well. Sunil Srivastava, now this is a limited victory. Interest on interest on loans even above 2 crore will have to be paid by the banks. How do you see that impacting the banks?
Interest on interest waiver, which had been given for almost 8 sectors, which comprised of loans below 2 crores, that was almost 99% by way of number. Now, 1% by way of number, but by way of amount would be a very large proportion. And in these cases, much would depend on how many of these borrowers actually opted for moratorium. So that if they have paid interest on time, there would be no requirement for interest on interest. So there would be a few sector-specific requirements there.
Okay.
Some sectors would have been impacted, like aviation, tourism, hospitality, etc.
Yeah.
And I'm sure they can make a separate representation to RBI or to Kamath Committee for reconsideration.
Okay, but now the banks cannot, the banks cannot charge them that interest. That is the law of the land as far as the Supreme Court has laid it down. Mr. Mehta, will this be a substantial amount on the banks?
Lata, I do not expect it to be a very substantial amount, as very rightly said by Sunil Srivastava, that only 15% of the large corporate borrowers have opted for moratorium. So total impact is going to be not that great, but it is difficult to tell you the exact impact it will have. That we will have to go back and calculate that.
Okay.
As regards the decision, now how it will be bounced, so we made our stand very clear in the Supreme Court as well as to the government that compounding of interest is a normal banking intermediary function. So we compound interest even for depositors, even for resources side also, and similarly for the borrower. So one side leaving it will be difficult, but government at its judgment can definitely come out maybe extending relief to the other sector. We are perfectly okay with it. There is no issues for that.
Okay. Thank you, Mr. Mehta, for joining us. Thank you, Ashmit and Mr. R.K. Bansal and Sunil Srivastava. So now we have to find out what will be that penal impact. Interest on interest for loans under 2 crore was waived and borne by the government. The balance, the RBI was simply making the principle. It's not the amount, it's the principle of banking. Bankers will have to compound interest on interest, both for savers, that is depositors, and for borrowers. And therefore, to keep the banking principle clean, the government stepped in and bore that as a fiscal forbearance that it is showing. Now that the court has said all interest on interest will have to be waived because the court considers it penal, will the government again jump in for whatever the extra the banks have to pay? Will there be a great deal of that money? Because a lot of loans will have to be restructured. Businesses and banks cannot wait for the court's judgment. They would have gone ahead with business and restructured. So maybe there is not much of an amount left, but this is still unfinished business. We have to see what that impact will be, if any, on the banking system and who picks up the bill. But that is perhaps a 25% problem for the banking sector. The larger issue, moratorium not extended, interest will not be waived, and no sector-specific decisions will be taken by the court because it is not the subject expert, are still positive developments for the banking sector, for the financial sector, and for the economy. Well, thank you very much for joining in this special discussion. We have to take a break, and thereafter it will be time for trading out.